Chair, Senator Galgiani, and staff. Thank you very much for the opportunity to testify. I'm Rosemary Shahan, President of Consumers for Auto Reliability and Safety. We're a nonprofit auto safety consumer protection organization. We've been active in protecting California consumers from a whole host of particularly auto lending related frauds and scams since 1996. And we would urge that the committee look beyond the practices that have triggered so much attention to other types of corporate malfeasance by Wells Fargo. There's a wider pattern of corporate illegality that hasn't received sufficient notice that's important to take into account. That this is a culture of engaging in illegality. And while Wells Fargo may try to scapegoat some of its employees, it goes much deeper than this one scandal. For instance, one of Wells Fargo's largest sources of revenue comes from penalties that are assessed on debit cards and other transactions. And Wells Fargo has been gaming that. There's a class action was brought against Wells Fargo. It was filed in 2007 that resulted in a court decision that Wells Fargo owed its California consumers the sum of $203 million in excessive overdraft charges. And what Wells Fargo did after the court rendered this decision, and these were practices that started in 2005 and 2007, was not to pay that amount, but to appeal the decision and then seek to have that decision vacated under the federal Supreme Court decision in AT&T Mobility versus Concepcion, which held that it was virtually impossible for consumers to join together in class actions, and that Wells Fargo sought to have that case shunted over to arbitration. Because the case was brought early on, prior to arbitration clauses in many of the contracts, California consumers are currently, finally, getting relief under a decision that I believe was before the California Supreme Court affirming the lower court decision. And so California consumers have now finally started getting paid back the excessive charges to their overdraft fees. But Wells Fargo is still continuing to fight a similar case that is in Florida regarding the same practices, and they're trying to force that into arbitration. And we see this pattern with Wells Fargo that when they're caught doing something, they just double down in their litigation to try to avoid having to pay back their customers what they owed and took from them unlawfully. And it just is impossible to believe that their litigation strategy is so separate from what the board wants and what the board is directing them to do. Furthermore, there's a U.S. Department of Justice case that was brought and recently settled with Wells Fargo, where they were illegally repossessing motor vehicles from military members who are serving our nation in active duty. And these are people who have volunteered to serve our nation and are many times putting their personal lives on hold, risking their safety to protect our nation. And under the Service Member Civil Relief Act, which has been around for decades, there is an obligation for financial firms to ensure that when people are serving our nation in active duty, that they don't have their car illegally repossessed, that their car isn't just taken from them like a thief in the night. But that's what Wells Fargo was doing. They neglected to check, or they deliberately overlooked the fact that these were active duty military. And this not only harms them and their families, but it also jeopardizes our national security. And the reason for that is when you're serving on active duty, for you to be like an intelligence officer, which is one of the main roles that our military is serving in war theaters around the world, you have to have a very high level of security clearance. In order to maintain that level of security clearance, you have to be able to demonstrate that you have financial responsibility and that you are not subject to some kind of influence because you're financially vulnerable. An auto repossession is one of the leading reasons why service members that we desperately need to do their jobs on behalf of our nation are unable to serve in the capacity for which they are very highly trained. This is unconscionable. This is reckless. This endangers our national security. It is beyond the pale. And Wells Fargo did this over and over and over again in a pattern of unlawful repossessions that started at least as early as 2008 and went through 2015. There were over 413 alleged violations. In addition, Wells Fargo is settled with the Department of Justice over illegal home mortgage foreclosures involving military personnel, where they agreed to pay $28 million for non-judicial foreclosures and another $59 million for judicial foreclosures. Taking people's homes and cars from them when they are serving our nation is, what can you say? You know, it should be disqualifying as far as any kind of responsible investment by our state. It's such a deep and enduring breach of the public trust. So we would urge that the committee consider requesting information from Wells Fargo about all their litigation, not just these cases that have come to light, but cases where people have sued, employees have sued, and victims have sued, and they've forced them into arbitration. We'd also urge that the committee look into the results of arbitration. California has an arbitration disclosure law that requires that our private arbitration firms disclose the cases that were filed and basic information about who filed them, whether they're a consumer case, an employment case, and what the outcomes were. I would think that that should be of great interest to this committee. What has been happening in arbitration regarding Wells Fargo? It's my understanding that Wells Fargo has usually used the American Arbitration Association to handle their arbitration cases. What is going on with AAA? How long does it take people to get a resolution? What are those results? What do they look like? And we do have a problem in California of non-compliance, where some of the arbitration firms have not been complying with our state disclosure statute. We've been urging our Attorney General and others to look at this issue and to enforce California's disclosure law. We know that when the Attorney General of Minnesota enforced the law based on data from California, they found that the National Arbitration Forum had links to a hedge fund that had an interest in the outcome of the results of the arbitration. And as a result, the National Arbitration Forum agreed to get out of the consumer arbitration business entirely after some very incriminating information came to light. We wonder if we have a similar situation in California.
Okay. Thank you, Rosemary. Thank you for your comments.
Thank you.
Appreciate your insight and experiences, difficult experiences that you have had.